oral hearings in this case were ongoing for months, and the judgment that was handed down was just the one Guyana was looking for. Guyana seeks a final settlement of the border controversy Venezuela raised in 1966, challenging the arbitral award which defined the borders of both countries.
The court concludes that by virtue of being a party to the Geneva Agreement, the United Kingdom accepted that the dispute between Guyana and Venezuela could be settled by one of the means set out in Article 33 of the Charter of the United Nations, and that it would have no role in that procedure. Under these circumstances, the court considers that the monetary gold principle does not come into play in this case. It follows that if the court, in its judgment on the merits, were called to pronounce on certain conduct attributable to the United Kingdom, which cannot be determined at present, this would not preclude the court from exercising its jurisdiction, which is based on the application of the Geneva Agreement. The preliminary objection raised by Venezuela must therefore be rejected.
That was Judge Joan Donoghue, the President of the International Court of Justice, handing down a decision of the court that effectively dismissed Venezuela's preliminary objection to the admissibility of Guyana's application for a final, legally binding settlement of the long-standing border controversy between the two countries. Venezuela had argued that the court cannot preside over the substantive case unless it made the United Kingdom a third party. Guyana disagreed, arguing that the United Kingdom is not indispensable because it has no legal interest that would be affected by a judgment on the validity of the arbitral award of the 3rd of October 1899. That award had fixed the boundary between British Guyana and Venezuela. Guyana further argued that the UK's interests were terminated on May 26, 1966, when Guyana gained its independence from the UK. The ICJ agreed with Guyana's arguments in a 14-1 vote, basing its judgment largely on the Geneva Agreement inked on February 17, 1966. In fact, the court said that there are several instances in the long history of the border case that indicate the UK was no longer participating in the settlement of the matter.
The court observes that the United Kingdom did not seek to participate in the aforementioned mixed commission procedure, nor did Venezuela and Guyana request the United Kingdom's participation. Venezuela's exclusive engagement with the government of Guyana at the Mixed Commission indicates that there was a common understanding among the parties that Article 2 did not provide a role for the United Kingdom in the dispute settlement process. The court further notes that Venezuela engaged exclusively with the government of Guyana when implementing Article 4 of the Geneva Agreement. In respect of the good offices process conducted by the Secretary General of the United Nations, again, the court observes that the United Kingdom did not seek to participate in the procedure set out in Article 4 to resolve the dispute, nor did the parties request such participation. Venezuela's exclusive engagement with the government of Guyana during the good offices process indicates that there was agreement among the parties that the United Kingdom had no role in the dispute settlement process.
With this preliminary objection thrown out, the World Court is now expected to return to the substantive case where the ICJ has already found it has the jurisdiction to preside over the matter. Guyana is seeking a final and binding judgment that the 1899 arbitral award, which established the location of the land boundary between then British Guyana and Venezuela, remains valid, and that the Essequibo region belongs to Guyana and not Venezuela. Reporting for the newsroom, I am Vishani Raghavir.